I have the honor and privilege of introducing Joel Thollander, who is a principal in the Austin office of McCool Smith, and he focuses on appeals and motions in complex cases. Mr. Thollander rejoined the firm in September 2006 after serving 2 years in the Attorney General of Texas's Office of the Solicitor General. From 2001 to 2002, Mr. Thollander was the clerk to the Honorable Craig T. Enoch of the Texas Supreme Court, and he has offered oral arguments in numerous appeals, including appeals in the Federal Circuit, Fifth Circuit, Texas Supreme Court, and the Texas Court of Appeals. Joining him today is Leah Buratti. She is also a principal in the Austin office of McCool Smith. Mrs. Buratti is a trial lawyer whose practice focuses on complex, high-stakes patent infringement and commercial litigation. She has extensive experience representing technology companies and clients in the oil and gas industry. Since 2014, Leah served on the board of directors of American Gateways, a nonprofit providing legal services to asylum seekers. Before joining the firm, Leah served as law clerk for the Honorable Carl E. Stewart of the United States Court of Appeals for the Fifth Circuit and Honorable Jorge A. Solis, the United States District Court for the Northern District of Texas. So without further ado, Joel and Leah, thank you so much for joining us today, and we are excited for you to close us out. So take it away. Oh, and before we do that, again, harping on and on, but please, anybody feel free to drop comments in the chat or in the Q&A, and I will bring those to Leah and Joel's attention so that they can handle them as they see fit. So again, thank you so much for joining us, and the floor is yours.
Thank you, Roy, and thank you, Carolyn, for putting this all together. I know it's a tremendous amount of work for you all, and we appreciate the opportunity to present today. Our topic is the biggest verdicts, an analysis of the Federal Circuit's treatment of high-dollar jury awards in patent cases. And we appreciate everybody sticking around late on a Friday to hear about this. Roy already introduced me, but just to kind of add on a few additional kind of maybe relevance points is that I largely focus my practice on patent damages. I've been a litigator with McCool Smith for the past 10 years and is doing primarily patent cases. And as the non-engineer on my team, I'm typically handling damages issues. So the topic for today's symposium and today's presentation is right up my alley. And before I also continue, Joel and I owe a huge thank you to our colleague, Brianna Messina, who, even though she isn't up here presenting with us, was a very instrumental part of this team in putting together today's presentation, especially in all the research, assembling the data, and analyzing the data.
Thanks, Leah. I guess this is the moment where I fill out my introduction as well, which is already pretty fulsome, but yeah, I would just add, I'm also don't have a technical background like Leah. So it took me a little while to jump into IP, but around 2007, 2008, which was probably 6 years into being with the firm, I started to work on the firm's patent cases, and in particular on the firm's patent-related appeals to the Federal Circuit. So I've had the opportunity, good fortune to work on many of those appeals over the last dozen years or so, including 2 that we'll mention today, which at the time that they were decided at least were at or near the top of the list of the largest patent infringement judgments affirmed on appeal by the Federal Circuit. That's all I've got, Leah.
All right. So a quick overview of what we'll be covering today. After a brief introduction, I'm going to talk about the methodology for our analysis of the Federal Circuit's decisions addressing the biggest jury verdicts, the biggest patent jury verdicts. Then we'll take a look at the data and the breakdown of the biggest verdicts and see what trends can be identified or teased out of the data. And finally, we'll wrap up by discussing some of our takeaways after analyzing the biggest verdicts. So the genesis for today's presentation was really our work day to day on patent damages and reviewing the Federal Circuit's many cases addressing patent damages. And the Federal Circuit's treatment of damages over the past 15 years for anyone who practices in this area, has been a bit of a wild ride. So we set out to take a look at the biggest jury verdicts awarded over the past 15 years and examine the Federal Circuit's treatment of those cases on appeal. We had kind of some hypotheses going into this, and we wanted to see if, if looking at the data really bore those out, and to see if we could identify any trends, any common characteristics, or any patterns in the big verdicts that the Federal Circuit ultimately signs off on. And really, I mean, even beyond what the Federal Circuit expressly says in its opinions, are there any messages there? So methodology, we started by identifying those patent cases over the past 15 years where the jury awarded $100 million or more. We excluded pending appeals. So we were interested in those that, the jury handed down the verdict and they were ready to go up on appeal, and ultimately did go up on appeal. We included kind of in our pool of cases analyzed, even cases where the jury verdict was vacated by the district court on JMOL before it reached the Federal Circuit, given that those cases ultimately are still addressed by the Federal Circuit on de novo review. So the Federal Circuit is still weighing in on the jury's verdict. So we identified 27 cases that fit this criteria, and those are the cases that were the focus of our analysis and that you'll be hearing a lot about today. We looked at whether each of those cases settled, whether it was affirmed, whether it was reversed. And frankly, many of the cases, it's not crystal clear exactly kind of what bucket you put them in procedurally. Lots of cases are reversed in part, vacated in part, remanded in part. You name it, there's some combination of different outcomes. And so, there's a little bit, I guess, of, more of an art than a science to categorizing some of these cases, but we did our best. And ultimately kind of our criteria was, did the jury verdict, survive both the district court and the Federal Circuit's review, or was the jury's verdict vacated? And that was kind of our sort of deciding factor for whether we categorized it as, sort of a thumbs up, yes, it was affirmed, or coded it green, as you'll see in our data, or not. We did our research just using public articles, Docket Navigator, Westlaw, and some personal knowledge for the cases that we were involved with. Because it's a presentation by a couple of lawyers, no such presentation would be complete without a little bit of a disclaimer. And so our disclaimer is just that, we're not statisticians. I'm a litigator, Joel's an appellate lawyer. And so it's entirely possible that our data set isn't perfect. If it isn't, forgive us that. But ultimately, our goal wasn't perfect statistical analysis. Our goal was to look at these cases in an overarching way and to see if we can identify any kind of jump out at you sort of trends or themes. And speaking of trends, let's turn to our trends and dive into this. As I mentioned, we started out with 27 big jury verdicts in patent cases. Because we were specifically interested in looking at how the Federal Circuit addresses these verdicts, we wanted to identify those that settled out before the Federal Circuit could weigh in. And so in reviewing those 27 cases, there were 2 that settled before the Federal Circuit could weigh in. And that works out to 7.41%, as you see here. In terms of percentages, this is kind of interesting information, in and of itself, or at least I thought so, in that, that 7.41% is dramatically lower than the average that you see for settlement of patent cases. And that's, I think there's, several explanations for that. The biggest, I think, is probably that, as we'll see after looking at these stats, a defendant in one of these big verdict cases, also has eyeballed these stats and understands that that the verdict, they have a decent shot at getting the verdict vacated at the Federal Circuit. And for these big verdict cases, that's a risk that they often are willing to take. They've already taken the biggest risk of letting it go to a jury, and that's typically sort of the point of greatest uncertainty in litigation. And so these defendants have already shown that they are, kind of willing to stomach that uncertainty. And then I guess kind of another perhaps lesser factor in sort of thinking about why so few of these cases settle after a jury verdict is that at this point, most of the costs are sunk for the parties. That's, it's arguable whether that plays a big role here, where there's so much money at stake that the costs of litigation relative to, the damages at issue are, there's just a tremendous imbalance. And so, again, like I said, arguable as to how much of a role that plays. Joel?
So we thought it would be worth looking to start as something like a baseline comparison at the overall affirmance rate for appeals to the Federal Circuit over the relevant time frame. So now these numbers on this chart are borrowed from Patently O blog, so credit goes to the Patently O blog for the analysis. But the bottom line is that at a high level, appellees defending district court judgments in the Federal Circuit historically have about a 70% win rate. So judgments are affirmed in their entirety, something approaching 3/4 of the time. So there's not any special significance in breaking the rate out by year, but it is interesting to see that the rate is fairly stable. And there's not a tremendous degree of variation in the rate year to year over the last dozen years at least. Let me go to the next slide. Okay, so here's the money chart, which represents the outcomes for these very large jury verdicts in the Federal Circuit. And Leah will take us through some of the significant statistical trends shown here in a bit, but if you'll bear with me, I'm gonna just talk about some interesting observations that can be made right off the bat. And also to start, I'll explain the chart a little bit. The height of the lines represents the total award. And keep in mind, while many of these might look low, the threshold is $100 million. So even the shortest lines are very large verdicts, and the high ones are incredibly high. As to the colors, the red lines represent an outcome in which the jury damages award was completely wiped out. And the green lines represent cases in which the damages award was completely affirmed. The two purple lines represent the cases where there was a mixed result, with part of the judgment affirmed and there was reversal or part of the judgment was vacated with respect to some aspect of infringement or validity or damages, but in which a damages award ultimately meeting our threshold still survived the Federal Circuit's review. So, for example, in the Carnegie Mellon case, that was the verdict was kind of approaching $2 billion somewhere, and I think when the Federal Circuit was done with it, it was closer to 300 million. So still substantial, but a significant drop. So that seemed appropriate to warrant a different color. In terms of just initial observations, the first thing that jumps out to me is that there's more red in this chart than green. And so we just got done looking at the overall affirmance rate, seeing it was 70%. This is telling a different story here. And in fact, of the 25 cases that made it to the Federal Circuit, only 9 were affirmed in their entirety of it, which is a 36% rate. And significantly, one of them, the second to the last one there, the GlaxoSmithKline versus Teva case is being reconsidered as we speak by the panel that issued the first judgment affirming the verdict. So that one may well disappear, in which case it would be closer to a 32% affirmance rate. Even including the purple cases, that this is substantially less than would be expected. Just outside of the context of these large judgments. So, and the sample size is small, and there are issues with the accuracy of the comparison to the historical rate for sure, but this does show that the very large verdicts awarded by juries are, survive less than half the time. So in particular, what the chart tells me is that the Federal Circuit is perhaps especially unreceptive to the largest of the very large verdicts. And the largest two were wiped out entirely. And the third largest, the Carnegie Mellon decision, which I just mentioned, was cut down by something like 85%. So to me, it calls to mind an adage, if you'll forgive me, that I learned from one of the finest trial lawyers that I've had the privilege to work with over my time here, and that's Sam Baxter. And he says, pigs get fat, hogs get slaughtered. So he says it in a much more entertaining way than I do. But that saying always stuck with me. And I generally took it to mean something along the lines of don't be too greedy. But in this context, what it tells me more specifically, how it speaks to me, is that understand that the bigger the judgment, the closer the scrutiny, and the harder that judgment may be to keep. So I think, that idea probably applies to the entire chart in terms of, explaining why there's more red lines here than we would expect. But it certainly applies with greatest force to the highest lines and the largest judgments. So we'll have to put a placemaker here to see what happens with the 2.1 billion verdict recently awarded by the jury in the VSLI v. Intel case. So, and turning from the colors to the cases themselves, and I'm not sure if you can read them well, but it's interesting that certainly among those first few in this damages symposium, there'll be some familiar names. These include some significant damage cases that are cited quite frequently now, like the Lucent case in 2009, which addressed the differences between running royalty licenses and lump sum licenses, as well as the EMVR, the entire market value rule, and the Unilock decision in 2011, which rejected the 25% rule. Other damages cases include the Eon Geophysical and Carnegie Mellon cases, which addressed lost profits and royalties in the context of cross-border use, foreign use. And then the Power Integrations case also turned on a violation of EMVR. So there are certainly some damages cases here, especially kind of front-loaded. But it's also interesting to see that the reversals certainly aren't limited to damages issues, and many of the other cases turned on infringement or validity, and in fact, the two biggest reversals turned on failures of written description and enablement requirements. So we see that the Federal Circuit is scrutinizing all aspects of these appeals from very large judgments. Regarding timing, the green and red lines seem to be fairly randomly interspersed, although it is interesting that no year has more than one large verdict affirmance aside from 2015 and 2020. So in those 2 years, in 2015, there were three large judgments survived. One of those was Carnegie Mellon, so maybe we want to call it 2.5. But, and then in 2020, there were another 3 large judgments that survived. And again, one of those is being reconsidered, so maybe we want to call that 2.5 as well. But anyway, take that for what it's worth. I'm not quite sure what to make of that, but we'll have to see if this is an emerging every 5 years pattern, and we get another spate of large jury verdicts being affirmed in 2025. A final observation before I turn this back over to Leah comes not from the chart itself, but from some personal experience. And as an associate, I worked on the I4I v. Microsoft appeal representing I4I, which is the first green line. And that case ultimately came to be known as the case in which the Supreme Court confirmed that invalidity must be proved with clear and convincing evidence. But that issue was really a small one through most of the case's life. And at the earlier stages, what really stood out to me was the powerful evidence of willful infringement. And I4I made and sold software for editing metadata content in word processing documents. And there was evidence at trial that Microsoft was aware of I4I, knew its software technology, knew the patent issue, and also understood that its decision to add similar functionality to a new version of the Word program that we all use every day would make I4I and its software, quote, obsolete. And yet Microsoft went ahead with the infringement. So that was a powerful story to tell the jury for sure. And a few years later, I also had the chance to work on the Versata VSAP appeal representing Versata. And that's the next green line on the chart, I think, although I'm not sure if it's actually in the right spot. But anyway, it is the next green line on the chart. And Leah worked on that as well. So if I misremember something, she can correct me. But willfulness wasn't technically an issue in the same way in that case, but there was a very similar story there of one company knowingly rendering another company's product obsolete. So that case involved a pricing engine software that used hierarchical structures to make complicated pricing operations more efficient. And Versata's product was called Pricer, and it was sold as a bolt-on to SAP's enterprise software. So you could have SAP software and then add Pricer onto it. And in a somewhat reminiscent move to the Microsoft case, SAP offered a new version of its own software that was intentionally designed to work, quote, just like Versata's Pricer. And it did that. And so again, that was a powerful story for the jury. So anyway, with those kind of personal experiences of mine, I wondered and checked to see whether willfulness allegations or similar kinds of competitor stories appeared to play a role in the large judgments affirmed by the Federal Circuit. And it turned out they did. It was a consistent theme. In 6 of the 9 affirmances, there was a finding of willful infringement. Versata would be a 7th case, which had the story I just told. And then the last 2 cases were the Apple, Samsung, and Sprint Time Warner cases, which involved, fierce competition between serious competitors. And there were also allegations of willful infringement in those cases, although there was no final finding along those lines. But anyway, I take away from this that being able to frame the issue in terms of willful, culpable conduct, and at least being able to tell a kind of black hat, white hat story is a recurring theme in the large verdicts that ultimately survive Federal Circuit review. All right, Leah.
All right. So I'm going to take us through, Joel commented on sort of our chart, if you will, in broad terms, and I'm going to take us through kind of some more granular looks at the data. We had some specific questions that we were just curious about and wanted to see kind of if any of our hypotheses held up. The first one was, whether there are any industry specific trends in kind of which cases are the verdict is affirmed in and which cases it's not. And as Joel said, kind of 9 of the 25 were affirmed. Of those 9, 3 involved medical devices, so that's 33%. With a data set this small, it's, you can kind of take what you will from the percentages, but that's a good chunk of the affirmances are medical device cases, or I guess I should say kind of medical device or pharma. And then, 66.7% involve other forms of technology. And there was no real sort of consistent trend in that other category. There's telecom, hardware, smartphones, you know, kind of a wide range of different industries covered there. But, you know, I guess kind of the consistent theme that you do see in our green bars is really not surprising, which is that the highest verdicts that are sustained are in industries that are very profitable, kind of in the modern economy, you know, pharma and high tech, and that the verdicts are against big defendants who are, again, among some of the most profitable companies today. And, you know, I guess I say unsurprising because, of course, given, you know, the damages model that, you know, any patent plaintiff has to present, the royalty base is going to be bigger for these, you know, big profitable companies in big profitable industries. So perhaps it's stating the obvious, but that seems to be the, you know, that's the one trend. So next, you know, we were interested in looking and seeing if there's any kind of consistent theme among the patent plaintiffs in these cases. And again, the takeaway was not, you know, not any sort of trend that just like hits you over the head with, you know, how apparent it is, but 11% involved university plaintiffs. That's just one. That's just Carnegie Mellon. And so that stat, I think, was just interesting to me because one of my theories had been that maybe, you know, maybe universities or research institutions would be sympathetic plaintiffs to a jury, but just Carnegie Mellon was the university plaintiff with a big jury verdict here. Alfred E. Mann is also a research institution, so they're not included in that 11.1%, but you know, also on the list of a big verdict that was affirmed. Noteworthy is that none of the affirmed jury verdicts involved NPEs. And, you know, I say that and I recognize that certainly people debate sort of who can be classified as an NPE and who is not. But at least, you know, I think what we can take away from this is that none of the plaintiffs in these cases were companies that acquired the patents and have never made products that practice their patents. So that was also just an interesting data point. So this slide takes a look at sort of second time around cases. And this slide actually was sort of the genesis for me of the idea for this whole presentation, because, you know, 3 of these big cases that are affirmed were affirmed after a second jury verdict awarding damages. So that's, you know, 33%. That's a pretty interesting kind of consistent theme in these cases that are affirmed. So I think you can probably safely draw from this that, you know, winning twice at the district court is a predictor to some extent of success at the federal circuit. If you can win a big jury verdict twice, that's pretty persuasive. So each of these cases, Versata, Renetics, and Apple versus Samsung, were, you know, the plaintiff won an initial verdict in their patent case, which was then reversed or vacated and remanded either by the district court or by the federal circuit. I think for Versata, which again, as Joel mentioned, you know, we were both involved in the Versata case. That one was, there was a JMOL granted by the district court on damages. And so there was a damages retrial after the first jury verdict. So in any event, in all of these cases, there was a second trial in which the jury, you know, a second jury awarded another verdict. So yeah, I mean, as Joel said, you know, I also was fortunate enough to work on the Versata versus SAP case. It was my very first case after joining McCool-Smith, and I was the most junior member on the trial team for the damages retrial. So a great way to dive into your first case, you know, your first case is to start with a case like that. But yeah, the second trial was a retrial on damages. So there had already been a finding of infringement that had not been vacated. So that's That's a nice place to be, I think, in terms of trying a case, is to be able to tell the jury that there's already been a finding of infringement. Also at issue there was an attempted design around that was being tried. And so as Joel said, just to kind of, add on to that, there was sort of this, there was that vehicle to tell a story of willfulness, to say, there was a finding of infringement, and SAP is presenting their attempt to design around, but it still infringes. And so that was, as it turned out, that was apparently persuasive to the jury, and they awarded an even bigger verdict the second time.
Yeah, I think that was just go back to that, it was kind of a shockingly bigger second verdict, because the first one was for 140 million, if I remember right. And then, the second one, when all was said and done, was close to 400 million. So it more than doubled, which is kind of crazy. It almost makes you think you should ask for a second trial. But I'm kidding, of course. But yeah, and I think you're right, Leah, that it's hard to get inside the mind of a jury, but I think that patch issue actually really backfired against Microsoft in that, at least from my perspective, in that second trial, because it made them, even though willfulness wasn't an issue originally, at that point it looked like they knew exactly what they were doing and they were still infringing. And so it really was effectively almost like a willfulness argument. And you all did a great job trying that. Okay, so this is back to me. We touched on this a little bit earlier, but this slide reflects that on the reversals, which were so what's my math? 14 of the 25 were completely reversed.
Yeah, I think that's right.
Okay, then that's basically, so 30% of those, approximately 20, whatever, were on the basis of validity, 43% on the basis of non-infringement, and 21% on damages, which is perhaps surprising. So I guess the clear takeaway is again that the Federal Circuit is not just looking at damages. It's the issues are being scrutinized across the board, and even beyond that. In fact, the damages was the sort of the lagging reason for these reversals, which could be surprising. But and not only that, but in fact, when I consider sort of validity issues and infringement issues and damages, and generally thinking about those issues, if you're at the trial level thinking about what you're taking on appeal, I think you'd be likely to think that the infringement issues would be the safest, because they typically are considered to have the most, sort of fact-based component to them, although all of each of these can have factual components. But anyway, so, in terms of thinking, if you have a jury verdict, which one is least likely to be reversed, you might guess infringement, but in fact, that's the ground that saw most of the reversals. Now, I assume that could be worth some further investigation. I assume there's some claim construction issues in there, which are legal issues. But anyway, I think that's the main takeaway, is that the court is scrutinizing all issues. It's not just looking at damages in these cases. Yeah, and there's the 14. So this slide is a little bit of a caveat, which Leah touched on at the beginning, in terms of the affirmance and reversal numbers that we've been using, because we've been kind of calling them all reversals, but some of the reversals technically are affirmances, in the sense that in four of the 14 cases where the district court, or Federal Circuit, where the damages award did not survive the Federal Circuit, It was actually because the Federal Circuit was affirming the district court's grant of J-Mal or other decision wiping away the jury verdict. So in some sense, technically, those could be considered affirmances rather than reversals, but the reality is that the J-Mal is considered de novo. So the Federal Circuit is basically independently coming to the same decision as the district court and deciding itself to wipe out large verdict, notwithstanding the jury's factual conclusions. And the bottom line is these are cases, either way, there were large jury verdicts that did not survive the trip to the Federal Circuit. So it seemed more appropriate and accurate to put them in the red line camp. But it is an interesting fact, and I mean, I guess it reflects that district courts in general are more deferential to the jury award than the Federal Circuit. Leah, did you have some other comment on this one?
Yeah. You know, I thought it was pretty interesting that, you know, in at least 10 out of these 14 cases, which I think is a pretty significant kind of eye-catching number, the Federal Circuit came to a different conclusion than the district court on JMOL on the JMOL decision. And I think it just, it shows what, the Federal Circuit's just looking at these big verdicts differently from the district court judges. It's anybody's guess as to what the reasons for that are, but it could be that, as Joel said, that the district court judges are just generally more deferential to juries. It could be that the district court judges are sitting there right with the jury, hearing the same evidence live, and it's the old thing of the difference between reading a cold record and sitting there through the testimony gives you kind of an entirely different sense of the case. Or it could just be that, the Federal Circuit sees, as a specialty court, it sees a lot more of these patent cases than each specific district court judge. Although, of course, there's, certain district courts that see, a very significant number of patent cases. But, that maybe kind of that plays a part in kind of the different approaches of the Federal Circuit and the district court judges and how they look at these big patent jury verdicts.
I will add to that, Leah, which will set up your next slide too, that the other thing that I take from this, and like looking at it from the perspective of a patent plaintiff, it basically looks like you get 2 bites at the apple, and where the apple is means you lose. like you have 2 chances to lose. The district court can wipe you out, and if not, don't worry, the Federal Circuit can do it too. So, but as Leah, as you'll say, I guess it's possible that maybe the arrow runs the other way, but it does seem kind of like a one-way ladder there.
Yeah. Well, I guess yet to be seen, if there's kind of this one possible case that we're about to take a look at. So GlaxoSmithKline is the case that Joel was alluding to. This is, it's a pharma case, and it has a lot of sort of very pharma specific issues. I don't know kind of if you can take that much from this case and apply it to kind of maybe more traditional, just straight patent infringement cases. But there was a big verdict, $234 million, an odd $1 million verdict. And the district court had granted JMOL of non-infringement. And the initial panel from the Federal Circuit reversed and reinstated the jury verdict. And at least from our research, it looks like that would be a first. That would be the one case that we've identified where the Federal Circuit reversed a grant of JMOL and reinstated the jury verdict. I think there's been other kind of instances where there's sort of been more of a mixed bag verdict from the Federal Circuit, where kind of some non-infringement findings may have been reversed, but it's the only one we identified where a jury verdict was reinstated. But that was pretty short-lived. The decision to reinstate the verdict was vacated, and rehearing granted on February 9th. And so I think the hearing on that rehearing just took place, I think, in the last 2 weeks, I think in late February. So I guess it's to be seen what the Federal Circuit does, whether GlaxoSmithKline, can and will be the one case that, is out there where the Federal Circuit reverses the district court's grant of JMOL and reinstates a jury verdict, or whether kind of we end up kind of, with an empty slide here where that's never happened. And again, I don't know that there's that much to be drawn from kind of however this particular case comes out. It looks like the grant of rehearing is very focused on kind of the pharma specific issues of inducements and labeling, and I guess it may not be that instructive for kind of general patent infringement cases, but it's interesting nonetheless. So takeaways, we've talked about a lot of the data. We've kind of sliced it and diced it different ways, and as we've talked about it, Joel and I have kind of summarized some of our takeaways from it, but we whittled it down to 5 big ones that were kind of particularly noteworthy for us. And again, as I said at the beginning, we were coming at this from the perspective of, what can we learn and take away from this and apply to our practice? And so the first takeaway, it did kind of confirm something we thought might be the case, and I think is probably conventional wisdom among patent litigators, which is that there is kind of some sort of danger zone in terms of big verdicts. And I say danger zone, I guess from the plaintiff's perspective, but there are big verdicts are going to get a different level of scrutiny is really what it boils down to, or what it seems to be the case. Verdicts over 100 million. And, we didn't look at verdicts under 100 million. Of course, verdicts under 100 million are still plenty big. And I don't know kind of where the bottom boundary of this, sort of scrutiny of these big verdicts is, but certainly any theme that's 100 million or more is going to receive just a harder look, probably both from the district court on JMOL and certainly at the Federal Circuit. And so, as we've described it here in this slide, it receives an unarticulated measure of heightened scrutiny at the Federal Circuit. I think it's gonna get careful review. There's no doubt about that. And then the second takeaway, and this, as I mentioned, kind of when we were talking about it, is a data point that was very interesting to me, and one that kind of drew my attention to becoming interested in whether there were any other trends to be drawn from this type of analysis. Is that second jury awards, if you can win a second big sizable jury verdict, that second verdict is more likely to stand. I think the wisdom of 2 juries, I guess collectively, is given greater deference than the wisdom of 1 jury, and so that's a pretty reasonable predictor of at least thus far of success at the Federal Circuit. I think Joel's going to talk about our other 3 takeaways.
So yes, willfulness evidence helps. Which I discussed earlier. It's it's common to think that being able to tell a black hat, white hat story will help secure a large verdict from a jury. But looking at the large verdicts that were upheld by the Federal Circuit suggests that being able to tell that same story to the judges on an appellate panel matters as well, and maybe is just as much, which is interesting. So, and it may just be part of the human condition to be less troubled by an outsized verdict when there is still some sense that, in fairness, the defendant may have had it coming. I don't know, but I think you'll want that kind of evidence if you're looking for a really big judgment. Settlement is a good bet, and if you're a plaintiff in particular. So, and they didn't get too much press here, but 2 of the patent infringement plaintiffs to walk away with the biggest paydays of all were the 2 that Leah mentioned early on, who settled prior to the Federal Circuit's decision on appeal. I'm not sure if we have all of the information public on those, but I believe one of them was the settlement was for in the neighborhood of $700 million. So that's not bad. You know, given the uncertainty, the high rate of reversal, settlement looks to be a good bet for plaintiffs in these large verdict situations. But it can also be good for defendants. As we discussed in the Versata SAP case, settling after the jury's initial $140 million verdict would ultimately have saved the defendant from a final judgment that after retrial approached $400 million. So, and you know, as Leah mentioned, damages only retrials can be hard for defendants because infringement is assumed going into the second trial, which can mean that the jury in the retrial never gets to hear some of the defendant's best evidence and arguments. So really, there are good reasons to settle for both sides. And finally, these big damages cases get close scrutiny across all issues. So keeping a very large damages verdict intact on appeal is going to be difficult without a strong case across the board on validity, infringement, and damages. So, and the higher the award, the better your overall case will need to be. So, and when you move from the, you know, if you move from the range where you're asking for an amount that starts with an M and it starts with a B, then I guess you got to cross your fingers and hope that Sam was wrong when he said that pigs get fat and hogs get slaughtered. Leah?
All right. Yeah, I don't really have anything to add to that. So that takes us to the end of our presentation. You know, we're happy to answer any questions, but I also know that it's, you know, it's Friday afternoon and folks are ready to start their weekend.